everyone, it's Bob Crossan, Senior Managing Editor for Water and Waste Digest. I am here today with Ashley Campbell. She is an attorney for SL Environmental Law Group. We're going to be talking about the PFAS health advisories recently announced by the US EPA and the impacts those could have on utility recourse for holding polluters accountable. So, Ashley, thank you so much for being here. We appreciate you taking the time.
Thank you so much for having me, Bob.
Yeah, this is a very big deal, these health advisories. It changes a lot of things of how utilities I know are looking at it. I'm curious how it's going to impact you guys as kind of the law firm trying to hold these folks accountable. What impact do you see from your vantage point working with SL? Like what do you guys see? What type of impact are you expecting here?
Yeah, so big picture, um, for holding these polluters accountable, I don't actually think the health advisory has a lot of effect on the legal theories, right? So all lawsuits have sort of two pieces. They have the legal theory. Are these manufacturers and polluters, are they liable under various legal claims that have been brought against them? Nuisance, trespass, product liability, various state regulatory schemes. That's one side, that's the liability side. But then there's the other side of the case, which is how much is it going to cost to clean this up? And so for the first part, for the liability question, the health advisories don't have a legal impact except perhaps for some state regulatory schemes. It's
Mhm.
really the other half, right? It's the damages half. This is going to be an exceptionally larger quantification of damages, right? You're going to have to clean to a lower level if the health advisories are an indication of where our regulation is going. But of course, as the EPA noted in their press release and in several sort of Q&A sessions they've been hosting, the health advisories are not regulations. They're a first step in a multi-step path to a regulation. And they're probably lower than what a regulation would be because the health advisories only care about health. They don't care about the feasibility of detection or the feasibility or cost of treatment. So very likely an ultimate national regulation or state regulations based on this health advisory will be somewhat higher than this number. But in any event, it's an indication that the cleanup levels will be lower than they are now, which would make that damages piece of the calculation higher.
Mhm. Yeah. So I know that you guys do a lot of work in holding polluters accountable, not just with PFAS, but with a lot of other contaminants as well. Could you talk about the how utilities can take that type of recourse against polluters who may be impacting their waterways, whether it's a wastewater facility or a drinking water facility?
Sure. So right now, there is litigation pending. It's called a multi-district litigation, which is just a procedural tool that courts use to put a lot of cases that are similar, usually filed against the same defendants on the same legal theories, put them all in one place. And they do that for two reasons. One, it's for efficiency for the defendants, right? The purpose of the litigation is for the defendants to pay to clean up. So you don't want them spending all of their money in litigation in a bunch of different places. Then the other is to support the efforts of the plaintiffs. All of the plaintiffs should be on the same playing field. They should be getting the same discovery. They should have the same benefit of the same procedural rulings from the same judge. So that's what the multi-district litigation does, is it sort of consolidates all of the cases before one or a few judges who become familiar with the case. And all of the discovery, all of the beginning part of the lawsuits all move forward together. And
Hmm.
that litigation is pending in South Carolina, but it's based on contamination from one PFAS containing product, just aqueous film forming foam, which is firefighting foam. Some cases that have maybe dual contamination or unknown contamination from PFAS are also there, but that litigation is supposed to be just from HFF. So if you're a drinking water facility or a wastewater facility, you can bet that some of your contamination came from HFF because it was used so prevalently. And because as a drinking water or wastewater utility, you're collecting all of that water that's in the ground for drinking or waste that's in discharge. So you've got some AFFF. So you're definitely eligible to go and be part of that litigation. And the good part for a water utility is that the litigation has been already pending for 3 years. So basically, you're jumping into a lawsuit that's already on its way, and you don't have to wait 3 years to get there.
Hmm.
So that would be a really promising course of action to hold these polluters accountable and make them pay for the treatment that you're likely to be required to engage in if you haven't already, because you get to shortcut that process.
So paying for the treatment is obviously the part of the end goal here is getting the polluters to pay for it because utilities and like especially water and wastewater utilities, they're not manufacturing this. They're trying to treat it and then they get saddled with all of this burden of the health advisories and then coming down regulations next year and whatnot as well. What are some of the ways that these types of cases have been used to hold them accountable in terms of the money? Because I know that, like for example, in New Hampshire, you guys did an entire case with MTBE that resulted in like essentially creating a bucket for a lot of utilities to pull from. Is that kind of the end goal for a lot of the stuff with PFAS as well, or is there a different model that you're looking at?
No, that's the model, right? So you use these legal theories again, regular tort law, nuisance, trespass, and then product liability law to hold these polluters accountable to pay for treatment, yes, so construction of a treatment facility, but then also long-term operation and maintenance, which I think many utilities expect that that's what they're asking for, but I don't necessarily know that, everyday customers realize the utility isn't just trying to build the treatment plant, they also need to operate it. And that's what your rates are going to, that's what your bill is paying for. And so it should be paid for by the both pieces of that should be paid for by the polluters, because particularly for these forever chemicals, they're going to continue being in your water sources for decades. That's going to be the more costly expense.
Hmm.
Um, but so the end goal is absolutely make sure that you have enough money to pay for these, 50-year
Hmm.
treatment obligations. Um, Individual utilities aren't going to create a fund like what the state of New Hampshire did, because they're just paying for their own treatment. The state of New Hampshire is paying for treatment for everyone in the entire state. But there are states in the multi-district litigation, there are states and sovereign tribes and territories that have also brought claims to multi-district litigation, and they can absolutely create a fund to help utilities within their jurisdiction to do that type of thing. But
Hmm.
there's one additional piece of funding that's interesting that came out with the health advisories. So along with the health advisories, $1 billion in infrastructure money has been made available to utilities, particularly disadvantaged communities, to apply for those initial construction costs. And so the way that the funding mechanism actually works is your state tells the EPA, we would like some of that money to help our utilities. And then the EPA doles out the money to states to use for their utilities. And utilities can also apply directly for another pot of funding. So the the health advisories didn't just come with scientific advice; they also came with this pot of money that can be used for those initial costs.
Yeah, 100%. That was something I was going to point out if you hadn't pointed it out. Is there is this $1 billion of the infrastructure bill that was announced with this health advisory announcement to help aid in this issue. But anyway, thank you, Ashley, so much for talking with us about this issue, this particular matter, and from the angle that you're talking about it. It's a very unique and interesting one in terms of PFAS because we're often focused more on the treatment side and then the disposal of it afterward as well, and the challenges involved there. But hearing how you guys are trying to aid utilities to hold these polluters accountable to make their lives a lot easier is really, really cool too. And for everyone who's watching, please check out the video description below. We'll have some links to some SL environmental resources as well as stuff on our website so you can learn more about what they do and how you can potentially be part of a legal strategy against these polluters.
Thank you very much, Bob.